Thank you very much for that very kind introduction. Thank you for having me. An absolute honor and a privilege. I hope I'm visible and audible.
Yes, sir. Completely, sir.
Right, right. So, Dr. Pillai, thank you for that very kind introduction. I'll try to be worthy of it. Uh,
Thank you, sir.
I can see that there have been very riveting discussions on the various specifics of forensic sciences, the various fields and implications and issues and so on. At the very outset, let me just add this caveat that I'm not a person of science, so to speak. I've in the last 10 years that I've spent in the legal field, both as a judge and as a lawyer, I've largely engaged with the forensics as a lawyer, either as a defense counsel or a prosecutor or a counsel for the victim or the friend of the court or the court itself. So that's been my brush with the system and forensic sciences. So I don't think I'll be competent or in a position to comment on the specifics of any of these sciences. But yes, what I can share or attempt to share with this very learned audience is how does the Evidence Act play out, and how does the Evidence Act deal with these different sciences and the different expert testimonies, and how are those appreciated? What are the sort of things that you can keep in mind when you are deposing as an expert witness? What is really evidence? Who is really an expert under the Indian Evidence Act? What are the kind of sciences or expert areas that are well regarded by the courts of law and the jurisprudence? What are the areas that are looked at with a pinch of salt? So would broadly touch those areas. The area of forensic science and the law per se is something that can take semesters to discuss and talk about. So what I'll be doing is essentially touching the tip of the iceberg in that sense. So without further ado, let me just start off, with what I'm going to speak to you about, and I welcome questions even during the talk or towards the end. So the thoughts are most welcome. I want this to be interactive. On the issue of what I'm going to speak about, the problem of proof, the law of evidence as it stands, and India has one of the most beautiful legislations in place, the Indian Evidence Act, which came up in 1872, which tells you what are the kind of evidences that can be led in a court of law, what is a fact, what is a relevant fact, what is an irrelevant fact, what are admissible pieces of evidence, who is an expert, what can they depose on, what is oral evidence, what is documentary evidence, what is hearsay evidence, what is primary evidence, what is secondary evidence, and how do you appreciate them? How do you cross-examine a witness? All of these things really is something that is in the domain of the Indian Evidence Act. Now, the 1872 law is something that has really stood the test of time. It is a beautiful legislation. And somebody said it very beautifully, that the Indian Evidence Act, and when you would be deposing or giving reports in a court of law, your interaction with the court would largely be governed by the Indian Evidence Act. There is also under the law something known as a criminal procedure code that really tells the court how to conduct a criminal trial. And on the civil side, if you were to depose in a civil matter, and there would be cases when you will be deposing in civil cases too, you would be governed by the Civil Procedure Code. So the Criminal Procedure Code and the Civil Procedure Code are the two laws that govern the issue of how trials are to be conducted by courts. How do you call evidence? At what stage do you call evidence? All of that. But your interface with the court when you are deposing either in a civil matter or in a criminal matter or in an arbitration case, your interface with the court is going to be governed by the Indian Evidence Act. Now, Indian Evidence Act says a few things, and just to get the basics out of the window before we get into slightly more nuanced issues. The Indian Evidence Act, of course, as the name suggests, deals with evidence. Now, what is evidence? Evidence is anything that makes anything else evident. This is what brings in the concepts of proof in discussion. When do you take something to be proved? What are the facts that are needed to prove something? Facts proof, all of this proved is something that the Evidence Act defines. Not boring you with, the definitions under the law, but broadly, these are the concepts. The Indian Evidence Act also tells you that there are certain relevant facts and there are certain irrelevant facts. So relevant facts, as the name suggests, are facts which have a logical connection to the case, which help the court or the judge understand the case better. Every trial is a voyage of discovery, with truth being the ultimate quest. So everyone is geared towards finding out the truth in a trial, right? So relevant facts are those facts which help the court understand the case better. As you understand, that in a court of law, the court is only trying to recreate what must have happened. The witnesses, who are the eyes and ears of justice, come to the court and help the court understand what really must have happened. And the court is now trying to understand what really happened. Did the accused really commit the crime, or it did not? So, and these, in this endeavor of trying to find out where the truth lies, the court receives evidence. And court receives evidence of relevant facts and facts in issue. Right? For example, in a murder case, just to set the context, in a murder case, what can be the relevant facts or the fact in issue? Now, the fact in issue in a murder case is whether A hit B with an intent to kill him, right? That is the heart of the matter, the core of the case. That's a fact in issue. But there may be many other facts surrounding this fact in issue, which would help the court understand the case better. And what can be those things? And here I'm talking about the concept of relevant facts, which is very, very important, because you would be deposing and assisting the court in that exercise. Now, what can be these relevant facts? Relevant facts, of course, I've told you, have a logical connection. And since all facts in this world are interconnected in some ways or the other, and no fact or no incident ever happens in isolation, these surrounding facts help the court understand the case better. This is also known as, and you must have heard this and appreciated this is known as the theory of circumstantial evidence. Even in those cases where there are no eyewitnesses, the case can still be proved. In fact, there is a saying that says that while the witnesses may lie, circumstances do not. So you can, by proving before the court surrounding facts which are relevant, help the court understand the case and decide the case in a fair and informed manner. Now, what can be these relevant facts in a murder case? For example, a relevant fact, and the reason I'm spending time on this is that this is the bedrock of the evidence law. Relevant facts under the Evidence Act may be, in a murder case, the fact that the accused had a motive to kill the victim. Maybe the accused had taken some money that he did not want to return back, and now the victim was insisting on repayment. And that is the motive that makes the person commit the crime. Now, this is a relevant fact. Motive by itself does not tell you who did it, but motive tells you who may have done it, and therefore becomes a relevant fact under Section 8 of the Evidence Act. The fact that there were previous strained relations between the deceased and the accused is a relevant fact. The fact that the accused and the deceased were last seen together at the heart or at the door of a jungle or a park, a deserted park, and nobody then saw the deceased alive after that, that is a relevant fact. This is known as quote unquote last seen together, where the court expects then the accused to explain what really happened because the deceased was last seen alive with you. This is a relevant fact. And you were having this discussion on CDR in the last lecture. CDR evidence is usually invoked for that purpose. For example, somebody's dead body is recovered, and the court is trying to find out who did it. And if by CDR location analysis, it can be asserted that the deceased was last seen with a particular accused, then the burden of proof would shift on the accused to demonstrate to the court that what really happened. The accused would have to then either say that, yes, I met the deceased, I saw him, and later we parted ways, and the deceased met somebody else and went with him. Or the time frame distance between last seen together and the time of death is very long. So accused would have to come up with an explanation. This is another relevant fact. Other relevant facts may be, for example, in a murder case, the accused comes up with the defense that I was not even here. I was not in Delhi, where the offense seems to have taken place. I was in Israel. And here is my call locations. Here is the CCTV footage that shows that I was there. Here is a stamp on my passport. Here is my visa, all of that. And here I have witnesses also to testify to that fact. That's also a relevant fact. That he was not there, he could not have done it. If the accused is repeatedly found to be complicit in similar situations, that is also a relevant fact. So the law broadly tells you what are relevant facts and what are irrelevant facts. Needless to say, when you would be deposing in a court of law, you would be deposing only on relevant facts and facts in issue, not on irrelevant facts. There is also this concept under the evidence law of admissibility. And relevancy and admissibility are both important preconditions for our evidence to be received in a court of law. But mind you, they are not the same thing. An evidence may be relevant to the matter, but it may still not be admissible. And conversely, an evidence may be admissible in a court of law, but not relevant. Let me give you one illustration each of these. And these two concepts are important when you are talking about the intersection of forensics and the evidence law, or the basics of evidence law. Now, for example, a police confession or a confession made to a police officer may be very, very relevant to the case, to the spectator or to the outsider. It is relevant because here the accused has admitted that he indeed committed the crime. So it is relevant. But law as a matter of policy says that any confession made to a police officer is not admissible in evidence. And why? Why this policy decision? Because the law believes that the police officers cannot be trusted to record statements correctly, impartially, and objectively. Only a confession made to a magistrate or the court under normal circumstances is something that can be received in evidence. But a confession made to a police officer may not be admissible in evidence. So you have an example of something that is relevant but not admissible. So this distinction of relevancy and admissibility also becomes important. I'll shortly come to on how does this play out in the context of an expert. Another important bedrock principle that may be important to be kept in mind is the distinction between a fact and an opinion. When you go before courts, normally what you depose on are opinions. You give an opinion, for instance, whether this bullet was fired from a particular gun or not on the basis of the marks and the grooves within the barrel of the gun. And then test firing, the ballistic experts would give his opinion. It appears that this bullet is fired from so-and-so gun, which is recovered from the accused. Then there is an opinion that this handwriting appears to be of the accused. These signatures appear to be of the accused. This voice appears to be of the accused. In narco-analysis, the accused said this, the possibilities of it being the truth or the falsehood. You know, all of these matters that you normally depose on are matters of opinion and not matters of fact. Because you are also essentially trying to do what is known as induction, right? You are trying to know the unknown from the known. You have some pieces of the known and you are trying to know the unknown from it. You know, it's very similar to saying that, you know, most Italians speak, or most people from Italy speak Italian. And X is an Italian or is from Italy. Then it is probable that X probably speaks Italian, right? It's induction. But when you talk about deductive reasoning, for instance, that all birds have beaks, parrot is a bird, therefore parrot has a beak. This is deductive. You are in the zone of induction where you're trying to know the unknown from the known, and it's a matter of probabilities. Therefore, what you are deposing on is opinion and not facts. Now, there is a body of law that tells you what happens in case the expert opinion is contrary to the facts as deposed by eyewitnesses. For example, an eyewitness says that the bullet was fired from X gun, and I was there. I saw it from my very eyes. But the expert in the case says, no, this bullet could not have been fired from X gun. We've examined, I'm a ballistics expert. Which is to take precedence? For example, the expert says that there are 2 bullets fired. The eyewitness says there is only 1 bullet fired. What is to take precedence? You know, these are the issues, again, which we'll briefly touch upon. I was telling you about admissibility and relevancy. I was telling you about facts and opinion. You know, as somebody very, very nicely said, that everyone is entitled to their own opinions, but not everyone is entitled to their own facts. Facts are facts, right? So that distinction we would have to bear in mind. Then there is this theory of circumstantial evidence, I've told you that there are no fact ever takes place in isolation, and all facts are interconnected. And if you can show to the court, even without eyewitnesses, from interconnected surrounding relevant facts that something happened or did not happen, that is the theory of circumstantial evidence. That is where your role would become the most important under the law. Another important bedrock principle that you need to keep in mind is the burden of proof and the principle of standard of proof. Why is the burden of proof important? Burden of proof is important because the burden of proof determines and decides who is to prove. We are dealing today with the problem of proof. Who is to prove anything? The normal principle is in a criminal trial, the prosecution has to prove. And the prosecution has to prove beyond a reasonable doubt. We'll come to the second part of the question in a bit. So prosecution has to prove. Normally the party who has brought the case before the court bears the burden of proof. Did the parents in the Noida murder case, where this young teenager was murdered a decade or two back, and the servant of the house, did the parents do it or did the other servants do it? Who has to bear the burden of proof? The burden of proof is on the prosecution. In a civil matter, the primary burden is on the plaintiff. For example, the plaintiff comes up before the court with a will, claiming that this will is the only last known will of the deceased and it is in my favor. The person who's brought the will has to prove the will, right? This is on the burden of proof. Another important question is the standard of proof, which is sometimes lost sight of. You have to prove. We've decided who is to prove primarily. But to what extent is something that, again, the evidence law guides you on. Criminal cases, I've told you, have to be proved beyond a reasonable doubt. Now, why is that? Because a criminal case concerns life and liberty of people, and it's literally a matter of life and death for the accused. Therefore, the insistence on a very high standard of proof. You know, we as students of criminal law, we learn that it is better to let 10 guilty go unpunished than to commit to prison one innocent person. So that is the ethos of the system. And that is why we still insist on a proof beyond reasonable doubt. Now, there may be discussions and there have been criticisms that given the state of investigative apparatus in the country and the problems of proof and with how sophisticated crime is getting, it is very difficult to prove a case beyond a reasonable doubt. And by beyond a reasonable doubt, you know, we have women and men of science here. People have argued that in order to prove a case beyond a reasonable doubt, you have to achieve a 90 to 99% certainty. There is obviously no absolute certainty in human affairs. Nothing can ever be proved to mathematical precision and accuracy of 100% normally. Therefore, a 90 to 99% certainty in the mind of the court that the accused must have committed the offense is a very high threshold. Many people are worldwide arguing and debating currently whether this standard of proof has to be lowered or brought down for the prosecution to have a realistic task. And this is, you know, the major pushback for this comes from the high number of acquittals that we have. Then this is on the criminal law side. Then on the civil law side, we have the principles of preponderance of probability, which means more probable than not. So all that I need to do in a civil case in order to succeed is, for example, I file a civil case against B and I say B has wrongfully taken over my property and I'm the owner of this property. I need to prove the question of my title and my ownership only to the extent of preponderance of probabilities, balance of probabilities, sambhavnaon ki prabalta. I only need to demonstrate to the court that it is more probable than not that I am the owner of this property. And the moment I've done that, the moment I've convinced the court to the extent of even a 51% probability in my favor, I've won that case. This is the distinction between a criminal case and a civil case. So 51% or more may also satisfy the threshold of preponderance of probability. You know, on preponderance of probability, we have the example of and this is taught by evidence law professors, a very interesting example. For example, let me put this to you, a hypothetical, that for example, in the state of, or the city of London, there are only two kinds of buses that ply or go on. One are blue buses and the other are red buses. The blue buses belong to, let's assume, the London Metropolitan Corporation, just like the DTC here in Delhi. These are the blue buses. 80% of all buses in London are blue buses belonging to the London Metropolitan. 20% buses are red buses. These may be private operators. Now, let's assume in an incident, a woman gets hurt by negligent driving of a bus. Now, the woman is not able to take down the license plate number or what is inscribed on the bus, but she has a recollection that I was hit by a blue bus. There are other witnesses also who depose that this was a blue bus. Now, if she sues the London Metropolitan for damages on the civil side, for recovery of compensation on the ground of negligent driving by the London Metropolitan officers or the drivers, all that she needs to prove is that it is more probable than not that London Metropolitan is liable. Now, let's look at it in terms of probabilities. And I must add the caveat that I'm not an expert here, and I'll leave it to your better judgment. All that she needs to prove in this case is that it is more probable than not it is a blue bus of the London Metropolitan which has hit me. Then the very fact that in the city of London, there are only two kinds of buses, 80% buses are blue, 20% buses are red. Now that figure or that statistical probability by itself should prove the case on a preponderance of probability. Because if all the buses 80% are blue, it is more likely than not that in this case it's a blue bus. And if it's a blue bus, then it's a case of London Metropolitan driving the bus. Now, obviously, this is apart from the question of negligent driving, whether there was negligence or not. But in the facts of the case, this may not succeed because in law, you have to prove negligence and existence of facts in that specific case. But all I wanted to show you was that there is an issue of preponderance of probability and the standard of proof. So when you're deposing in a criminal case or a civil case, the expectations from you may be different. This is also highlighted in the celebrated case of O.J. Simpson. I don't know how many have examined that case. It also used to be this amazing Netflix series called The Great American Crime Story, which talked about the O.J. Simpson case where a celebrity in the US was accused of having murdered his wife. Now, this was a murder trial on the criminal side, and it was also a civil trial on the civil side for compensation. On the criminal side, the accused gets acquitted because the prosecution is not able to prove guilt beyond a reasonable doubt. And it's very interesting how that plays out. And I don't want to spoil the series for you. You must check it out yourself. At one point in the trial, the accused is alleged to have been wearing a glove while committing the murder. And in the witness box, the accused tries to put the glove on and the glove doesn't fit. And that is where, you know, the famous line was argued by the counsel that if the glove doesn't fit, you must acquit. So to cut the long story short, on the criminal side, the accused is given the benefit of doubt and acquitted. But on the same set of facts for the murder of the same wife, same woman, he's found to be liable on the civil side and damages are granted. This would tell you what is the difference between the standard of proof on both sides. So very, very important. There is a third standard of proof that is coming up in law. So I've told you proof beyond a reasonable doubt, about 90 to 99% certainty. Preponderance of probability, more likely than not, 51% certainty would also do. Now, there is a standard of proof between these two, which is being implemented in certain countries, which is known as a clear and convincing evidence standard test. If you have clear and convincing evidence as a judge, the evidence may not match up to the very high threshold of proof beyond a reasonable doubt, but it is still clear and convincing evidence, about a 75% probability. Even that is acceptable in certain cases. For example, in Scotland, I've been told they have this principle. So it's very, very important for us to examine this. Now, the burden of proof or the standard of proof may also differ in different settings. A criminal trial, I told you, has a different one. A civil trial would have a different one. For example, if the parliament is sitting on an impeachment motion of a Supreme Court judge, we know that Supreme Court, High Court judges cannot be removed except by impeachment in the parliament. When the parliament is deciding whether the honorable judge has committed a misconduct or not, what is the standard of proof that they rely on? What is the standard of proof that medicine relies on before permitting a particular drug to continue or to be introduced? These are important questions. The counting of probabilities. Now, let me also, since you deal with probabilities as a matter of profession and as a matter of daily work, another interesting example is this. For example, in a criminal matter, and please, Dr. Singh, tell me if I'm running out of time. I belong to a species where we file a 1,000-page document in court and still call it a brief. So we have this tendency to go on and on and on. And
we had time, sir. We had time, sir. You can continue.
Because I also want to have some time for the questions.
Sure,
so
sure,
just
sure.
indicate to me, maybe 5-10 minutes before I'm about to, or I'm
Sure,
due to. Thank you very much. So, take this example of Mr. Henry. This is a interesting case. It was a criminal matter where Henry was executed of having committed a sexual assault. Now, in terms of the evidence in the case, the jury or the judge came to the conclusion that prosecution has not been able to prove its case beyond a reasonable doubt. They have only been able to prove that Henry has done it to a certainty or a probability of 80%. 80%, I've told you, is not good enough to convict somebody. Obviously, we lawyers and judges don't normally calculate probabilities in terms of numbers. And, most of us are mathematically challenged in that sense. We're more art students than science or math students. But in that case, let's assume the court was convinced to a degree of 80%. Could not convict. Now, this man, Henry, for instance, has 4 different cases of sexual assault against him. And in all of those cases individually, there is an 80% chance that he's done it. In all of those cases individually, he would be acquitted because the prosecution could not prove it beyond a reasonable doubt. But overall, now it appears that there is a greater probability that he's committed at least one of these sexual assaults on the anvil of probabilities. For example, there is this formula that I can't understand, maybe you can, where you calculate the probability of each of the case, 80%, 80%, 80%, 80%. When you put those 4 80% together and then try to find out what is the overall probability that Henry has done at least one of these, even if we can't pinpoint which one, then there is about a 99% chance overall that I've been told that he's committed at least one. But you can't convict him. But can this analysis be used while somebody is taking a decision whether Henry should be employed as a headmaster of a school, given his previous propensity to commit sexual assaults? These are questions that the evidence law till now at least doesn't answer, right? This again on probabilities and the standard of proof. On oral evidence, now there are 1 or 2 things that I'll tell you about oral evidence. Now, a person can be a witness for one's own case also. Oral evidence is something that we've traditionally relied upon a lot. There is overwhelming reliance on witnesses. We have this misplaced belief in the sanctity of oral evidence. We also have this exaggerated belief in the sanctity of oath in this country. And traditionally, most evidence has been oral evidence. Now, oral evidence, it has been shown, and I don't need to tell this learned audience, that oral evidence is susceptible to a lot of problems. Problems of wrong identification, problems of mistaken perception, problems of motivations and false testimony, subconscious biases, logical fallacies, imperfect recollections, embellishments, ex post facto rationalizations. All of these problems are problems of oral evidence. In fact, I love to talk about the study of Loftus and Palmer on how. So when I talk to young lawyers about cross-examination, I like to use this. So Loftus and Palmer were two people who did a study on eyewitnesses and how believable or unbelievable they should be. And Loftus and Palmer, after doing the study, came to the conclusion, or let me tell you first about the study itself very quickly. So a number of people, and this was a study done or a test done, a number of people were shown the same video of one car colliding with the other. Same video shown to different participants. It is one car smashing into the other. Once they had seen the video, they were put questions such as, what do you think was the speed of car A when it hit car B? This was a question put to one set of interviewees. The second was, what do you think was the speed of car A when it smashed into car B? The third was asked, what was the speed of car A when it brushed past car B? And mind you, these are witnesses perceiving the same video, looking at the same video. But their answers on what the speed would have been changed dramatically on the basis of how the question was put. For example, people who were asked, and this was shocking to me the first time I read it, the people who were asked, what was the speed of the car when car A smashed into car B, were more likely to give a higher number, like a 50 miles per hour. But people who were asked something on the lines of what was the speed of car A when it brushed into or brushed past car B, they sort of lowered their analysis in terms of the speed. They would say 30 miles an hour because it's a softer expression that one has used. So Loftus and Palmer talked about how problematic eyewitness testimony is and how by clever questioning, ideas can be implanted, modified, tampered with in the minds of the witnesses by clever questioning and clever cross-examination and clever choice of use and use of words. Another interesting example that they gave was the question of the filling in technique of the mind. They talked about the filling in technique of the mind. They say the mind hates a vacuum. And this I'm talking about from the standpoint of an eyewitness. For example, some eyewitnesses are deposing on a car accident again. Now, when they are deposing in a court of law, they are likely to say that there was a car accident and yes, there was smashed glass lying on the spot of incident, even if there was no smashed glass. Why? Because we associate smashed glass with car accidents, and when we are recollecting, our mind is playing tricks on us and we try to fill in the entire scenario. We would see skid marks. We are more likely to see smashed glass even if there was no smashed glass. All of those things. And this is something that sometimes impedes a discovery of truth, because a cross-examining counsel can then raise questions on the credibility of the witness on the ground of imperfect recollection. For example, the witness saw glass where there was none. So these are the problems. Then there is something known as a Rashomon effect, where different witnesses perceive things differently and depose in a court differently. The same incident, but they would be perceiving it differently. And that is what a cross-examining counsel benefits from. Then there is a problem of wrong identifications. For example, in a test identification parade, a witness looks at the accused and says, oh yes, this may be the one. And then a police officer or the magistrate may sometimes subconsciously or unconsciously would say, oh yes, that's you're right, or something like that. And that reinforces the witness's identification, which may be wrong. But just because there is some external validation or reinforcement, the witness believes that he or she is right. These are the problems of, oral evidence, and why, conversations such as this are very, very important. In terms of expert evidence, if I just come to this, for a minute and two, Section 45 of the Evidence Act tells you that an expert opinion is also admissible. Now, what are these? It doesn't tell you who an expert is. That at the end of the day would be a fact-specific issue in each of those cases. Who is really an expert? And this may be in handwriting, this may be fingerprinting, this may be DNA, ballistics, blood splatter experts, forensic toxicologists, crime scene reconstructionists, psychologists, computer forensics, voice sampling, lie detection, narco analysis, multiple disciplines. The Evidence Act doesn't tell you, and it's an 1872 law on who would be an expert. But it is generally believed somebody who's well equipped or competent or learned in a particular science, a matter of science. And that sign has some broad hallmarks of reliability. For example, it is a science that is based on falsifiability. It can be tested. It is peer reviewed. It is generally believed to be a correct or a cogent, legitimate science. It can be measured. It can be to some extent disproved or proved. So all of these elements leads to something known as a science on which an expert can depose. Now, expert can depose after proving the expert's competency in that area, but that doesn't mean that evidence would be taken at face value. That evidence is always subjected to a cross-examination by the opposite counsel or a questioning by the court. The court has power to ask any questions. So the probative worth of an evidence of an expert is different from its admissibility. Your evidence may certainly be admissible. And when I say admissible, your evidence would be looked at by the court while deciding the case. But it may not be conclusive. It may not have probative worth. The court may admit it, look at it, but may not rely on it for a number of reasons. So probative worth and admissibility are two different points. Now, what are the different areas of expert sciences and how does the law deal with them? Now, personally, of course, we've seen handwriting tests. There is a lot of debate on the accuracy, the reliability, and this may differ across cases. We've seen cases where we have experts on both sides who have contrary opinions on whether the letter was written by the same individual or not, or what are the probabilities, whether it is likely, most likely, unlikely, the use of those words, how important those words are. So we've had cases of opposing views on handwriting, fingerprinting, DNA, ballistics. We've had different opinions on forensic toxicology, on the presence of a particular element in the deceased body. We have psychologists who've come in as experts to depose in cases deposing contrary. For example, one psychologist in a domestic violence case comes up and says that the conduct of the accused is a conduct of a narcissist or somebody who has a personality disorder. But at the same time, the person accused in the domestic violence case may come up with evidence saying that what I did was only in grave and sudden provocation or as a reaction to what my spouse did to me. So what I'm suffering from today is not really narcissism. I'm suffering from PTSD, a post-traumatic stress disorder, with a view to explain or mitigate some of the crimes. So you will have opposing. You will have cases where experts would come and depose that the accused murdered her 5 kids, and this is a reported case, due to postpartum psychosis and schizophrenia, and not because of any other thing. You have computer forensic experts. We already have experts who are deposing, and every case has an electronic evidence component to help decide cases. For example, you must have heard of this very interesting case that happened in the US, where a man made a claim in insurance for his house having been burned down at a particular day and at a particular hour. And later, from his pacemaker analysis, it was found that this was a false insurance claim because on that day, he was under no stress. There absolutely his physiological markers, his heart rate, his respiration rate are not disclosed, no activity at all. So you have those. Voice sampling. You have some controversial sciences. For example, bite mark is a very controversial science on how reliable it is. Hair comparison sometimes is very reliable or unreliable. Lie detection in some cases may not be as reliable. Although I believe lie detection also as a discipline in India is entitled to greater consideration. We've thrown out today lie detection, narco analysis, brain fingerprinting, fMRIs, lock, stock, and barrel. We do not rely on them at all. In a court of law, they are not admissible. But if, for example, under the influence of narco analysis, if it is done voluntarily and the accused gets discovered, the weapon of the offense. Only that part which leads to the discovery is admissible. This was the judgment of the Supreme Court in Selvi's case. My argument is that, or my submission is, which should be considered, and we can debate on this, that these lie detection or some of these newer sciences, for example, there are sciences today which, on the basis of eye movements and the temperature around the eyes and the pupil size, can to a 70%, 76% divine whether the person is speaking out of guilt, shame, and deception, or is it on some sense. And if you actually compare it to how judges and juries decide, this may be actually more reliable and credible than a jury deciding, because we human beings, howsoever highly we possibly think of ourselves, are terrible at picking lies. What we may perceive as a sign of lying may also be a sign of nervousness in a genuine witness. So what really needs to be kept in mind today is, and we made this recommendation in the new law too, that these sciences should be relooked at. If there is a technology or an expert thing that we can harness and have better decision making, then why not? Also, what we are arguing for is, in certain cases, for example, there are two experts on either side deposing on a particular issue, then we are arguing increasingly for a hot tubbing of the experts, where both the experts can come together in the witness box and fight it out and answer the questions of the judge and the counsel, instead of both experts speaking differently and being cross-examined differently, where sometimes truth is the casualty and judge is not able to appreciate who really to believe. And sometimes the experts can ask questions inter se to each other to help us find out the truth. And this is something that is being implemented in intellectual property cases in the Delhi High Court. I'm happy to inform you it is there in the rules, but we are trying to get it implemented also on maybe the criminal side or on the civil side and other similar matters. I now feel that I kind of overshot the time. Thank you very much for this opportunity. I tried sharing my broad thoughts. Happy to take any questions, or thank you.